This video may contain what could be considered attorney advertising under the rules of your state. This video is for information purposes only and should not be construed as legal advice. If you have a legal problem, it's vital for you to seek out and talk to a licensed attorney for advice. Good morning, good evening, good afternoon, wherever you may be. My name is Chris Simmons, attorney at law. And today we're going to talk about arbitration. This is the second of two videos. The first video dealt with dispute resolution, what is it in general, mediation, negotiations, and why you may choose one of those methods of dispute resolution over going to court. Today we're going to talk about arbitration only, and that's because there is certain controversies that go along with arbitration that I'd like to address. Now, the same reasons that you may choose other forms of dispute resolution over going to court still apply to arbitration. It's faster, it's cheaper, it's less formal, and you can customize it a lot more than, say, going to a court, where you have federal and state guidelines that you must abide by. An arbitration agreement is just a contract between two parties. So, before we get into the controversies, let's talk about what arbitration is in general. Arbitration is just a less formal version of a court proceeding. You have an arbiter who acts as a judge. Both sides present their case, present evidence, present whatever arguments they may have. The arbiter hears both sides, they make a decision, they write an award, which is their judgment. And at that point, the arbitration award can be enforced just like a court judgment. In fact, most courts will enforce an arbitration award just as though it was a judgment. Now, there are some advantages to arbitration, and you may view this as a disadvantage depending on your view. Arbitration is less formal. You do not, unless it's written into the agreement, have to abide by the rules of civil procedure, the rules of evidence, or any other court procedures. You can bring in hearsay. You can bring in a surprise witness. You can do those things. Is it bad form? Maybe. Who knows? It depends on your case. But you are allowed to do that, whereas in court, you can't bring in hearsay evidence. In court, at least in federal criminal court, you can't bring in the surprise witness despite what we believe when we see it on TV. That's not actually going to happen. But in arbitration, it could. Because you don't have to reveal your case, you don't have to reveal all the evidence, you don't have to share everything. So, in a way, arbitration is a lot more exciting than a court case. But on the other hand, arbitration is also a little bit disadvantaged in that you don't have all these rules. So there's a general way you do it, and lawyers and attorneys who are trained in arbitration kind of know the standard procedure, but sometimes things can go a little haywire depending on your arbiter. And that's why you want someone who knows how to arbitrate as your arbiter. Now let's move on to some of the controversies and the efficacy of some of these practices. First, I want to deal with the one that I find the most egregious, the one that I don't agree with, and the one that I think should not be done. I want to preface this saying that it is a legitimate tactic. It is something that people legitimately use for various reasons. It's when it's not done for a good reason that I have an issue, and that is choosing a specific place to arbitrate. Generally, if you're a corporation, you're working nationwide or internationally, you're going to want to arbitrate in your home district because you want everyone to have to come to you. You don't want to have to go out to 50 states or 100 countries and arbitrate. You want all of these to come to you. That I can understand. The controversy, and the one that I think is unethical, is, and I'll give you this example. I don't know the company's name, not off the top of my head, but I do remember seeing in an arbitration agreement that an American company, in a company based in, I believe it was California, either California or Kentucky, one of the two, their arbitration agreement said that all disputes must be arbitrated in Egypt, Cairo, Egypt, to be specific. Again, they're an American company. They're based in either California or Kentucky. I know that's a long ways between the two states, but one of those two. Most of their clients were American. No American is going to fly to Egypt to take on the expenses of going to Egypt to arbitrate. So their clause, by placing arbitration in Egypt, very anti-consumer, very, very anti, it's unethical, is the words I'm trying to think of. And it's a deterrent to being sued, to being brought before arbitration. So that I don't agree with. That I think is completely unethical, should not be done. But when you're requiring people to come to you to arbitrate because you're going to do everything nationwide, I much more understand that. And that is much more ethical. And depending on how pro-consumer it is, I can understand a little bit better. But let's move that aside. Let's take that issue and move it aside and deal with the more common controversy surrounding arbitration. And part of this, I think, is because there's a misconception on what exactly the rules and process for arbitration is. That is forced arbitration clauses. Now remember, arbitration, quicker, faster, those are the same thing. Quicker, cheaper, less formal, and it can be enforced, just like a court's judgment. What people don't like is signing away their right to sue in favor of these arbitration clauses. And I think, depending on the arbitration clause, I understand that. Because if the arbitration clause is pro-corporate, is pro-business, is pro-whoever has that arbitration clause, I understand the rationale. However, some of them are very pro-consumer. So let's talk about what a forced arbitration clause is, and then we'll deal with some misconceptions on how arbitration works, and maybe we can work out why some forced arbitration clauses might not be a bad thing, and some of them might be. A forced arbitration clause is simply an arbitration clause that is placed in a contract that you cannot get rid of. You can't change it. You can't get rid of it. You can't strike it from the contract. If you do so, the company's just not going to sell to you. I guarantee, look on a airplane ticket or on the contract related to the airplane ticket, there's an arbitration clause on there. If you want to fly, you have to arbitrate. I don't know if they're pro-consumer or anti-consumer. I haven't read one in a while. I flew last month, but I didn't take the time to read the arbitration clause. I know I'm an attorney, I should read everything, but frankly, we're consumers. I'm a person just like everyone else. No one reads every contract they sign. We should, but we don't. But if you go through every contract, you'll find arbitration clauses in many of them. And these are generally forced arbitration clauses. The question becomes, is it pro-consumer, or anti-consumer? But let's talk about misconceptions with these. The misconception is the arbiter is just going to be pro-corporation. They're just going to work with that corporation because they want to get hired again. Because these are private individuals. They're essentially private judges. So I take issue with this because under most arbitration agreements, you deal with the rules as is laid out by the American Arbitration Association or other similar arbitration groups. The American Arbitration Association can provide a list of, say, 7 arbiters. And both sides will get to strike names from that list. And any attorney who's doing this, who knows what they're doing, they're going to do background checks. They're going to read prior decisions. They're going to read everything about those arbiters. They're going to know arbiter A, C, D, and E are all pro-corporate. Arbiter B, F, and G are pro-individual. Arbiter A is the most balanced of all of them. And the lawyer for the consumer is going to mark off every one of those except for A. Every one of those anti-consumer except for A. The corporation is going to mark off every one of those except for A, that were pro-individual. And you're stuck with arbiter A, who's the most balanced. He or she may still have some type of bias towards corporation, but here's the beauty of this, the second part of this. At any time, because it is a contract between 2 parties and it must be agreed upon, if the consumer believes that the arbiter is biased, unfairly biased, they can dismiss the arbiter. And they get to choose a new one. That can cost a lot of money though. So you have to be sure. And sometimes that will be brought to court, but again, it's a private contract. So at any time you can eliminate bias. But here's the other thing. Again, I told you any attorney worth their salt is going to do their background research on these arbiters before choosing which ones to get rid of. If an arbiter gets through that is just blatantly pro-corporate, they damn the facts, we're going to side with the corporation. Or if it's pro-consumer, damn the facts, we're going to side with the consumer. That arbiter is never going to get chosen to arbitrate again. So there's a way of dealing with the bias. Most people don't realize that, and therefore they believe that arbiters are just always going to go with the corporation because that's who's going to hire them constantly. Now, you don't have to go through the AAA. You can hire your arbiters however you'd like. For example, and this is slightly advertising, I guess, I offer arbitration services. If you and the person you're having a dispute with wanted to hire me, you would both have to agree to hire me. If you didn't, if, say, the company wanted to hire me, but the individual didn't, I would not be able to arbitrate because they can't agree. So there's always this back and forth, okay? So that's the big issue around forced arbitration clauses. Outside of that main issue that I find unethical when you use location as a deterrent from being sued, that's the thing. That I find arbitration is fairly good as long as the arbitration clause is neutral or pro-consumer. If it's pro-corporation, they're the ones writing, they're the ones in charge, they're the ones that have all the power. And therefore, I find that forced arbitration clauses that are very pro-corporate can be damaging. But again, it all depends on on who is writing the arbitration clause. And sometimes you can work around this, and sometimes you can find alternatives. Sometimes the corporation will actually work with you. So I want to finish up with one advantage that mediation negotiation does not have, that arbitration does over going to a court. I referenced this in the first video, and I want to talk about it now. There is arbitration treaties. And if you don't know how a treaty works, in a nutshell, a treaty ratified in the United States has the same power as a statute, as a regular law within the United States. But this treaty is signed by a very large number of countries around the world, and what it basically says is that an arbitration award awarded in a country that is a member to this treaty can be enforced in any nation, in any country that has also signed this treaty. Court judgments, while there are some similar deals, these are less common. So arbitration awards are easier to enforce worldwide than a court judgment. So in addition to being cheaper, in addition to being faster, in addition to being more customizable, in addition to being able to pick your own judges, to bring in hearsay evidence if you believe that's a good thing or a bad thing, that's up to you. But in addition to all the other advantages and possible disadvantages, arbitration awards are binding if you have binding arbitration and enforceable wherever. And as a final point, mediation, going back a little bit, if you want this same thing, it is possible to simply write a mediation award, the deal, as an arbitration award, call it arbitration, and suddenly you have this same thing. Now there are formal steps, and you would need to talk to an attorney to make sure it's done correctly. But arbitration is essentially private law, as is most contracts, that allows disputes to be resolved quickly, efficiently, and without the court having to waste resources. The court system itself favors arbitration, favors dispute resolution, and favors settlement. In fact, courts, I would say 99% of all cases before a court get settled before trial, before a judgment is ever done, through different types of negotiation, mediation, and arbitration. Less arbitration, more mediation, negotiation. Arbitration takes the place of courts. This is because everyone has a right to sue, but the courts don't have the time for everyone to sue. So they prefer these alternative methods to dealing with problems to save money, to save their time, so that they can focus on other things, on the cases that really do need court supervision. So for me, read arbitration agreements. See if they're pro-corporate. See if the place that the arbitration is supposed to take place in is some far-flung country, or if it's the home of the corporation, or if it's really pro-consumer, where you're located at. I have seen a few like that. And figure out if arbitration is right for your situation. I push dispute resolution hard. I believe that most things can be taken care of through civil discussions, through negotiations, through mediation, and ultimately through arbitration if it needs to be. I hope you've learned a little bit about arbitration. I hope you've learned a little bit about mediation, negotiation, dispute resolution in general. I hope you can at least, even if you disagree that we should mediate or arbitrate instead of just suing, I hope you can at least see why arbitration dispute resolution is pushed so hard by courts and why it's a preferred method for business. Again, watch out for how they go. Hire an attorney if you're going to do arbitration. Make sure you get a good arbiter, and make sure that everyone knows what they're doing. I hope you've enjoyed this. I hope you've learned something, and I'll see you in the next discussion.